Good afternoon, everybody. Welcome to LEARN, Lifelong Education and Aging Resource Network. Today we are going to talk about estate planning made easy, and we have Carly Ward, attorney from Idaho Estate Planning with us to talk about that. And before we get there, I want to tell you a little bit about LEARN. If you haven't been on one of our webinars before, LEARN is a lifelong education and aging resource network, and we're an Idaho-based nonprofit organization with a mission to provide quality education on retirement, age-related topics in the area of health, wealth, lifestyle, and caregiving. And LEARN is a leaders network of the Society of Certified Senior Advisors. As a disclaimer, this content is provided for general informational purposes only and is not to be considered legal, financial, or health advice. We do have an attorney today, but consult with your legal, financial, healthcare, or other service providers before taking action based on this information today. And I would like to first do an introduction of our sponsor. We're so pleased to have Fairway Independent Mortgage Corporation be our sponsor for our summer quarter education series. And that allows us to present this information to all of you free of charge. And so we greatly appreciate Fairway Mortgage for providing that support for LEARN today. And today we're going to hear from Carly Ward, who is a JD, an attorney with Idaho Estate Planning. And Carly has a degree in political science from Brigham Young University, Idaho, and a law degree from Concordia University School of Law located in Boise, Idaho. Carly is passionate about helping families make long-term plans and solve complicated care and estate problems, and has received comprehensive training on asset protection and Medicaid. Carly resides in Boise and enjoys coaching for the Meridian Ace Fast Pitch Softball Club. Love that, Carly. Thank you so much. And thank you for being with us today. So Carly, you're welcome to take over the presentation whenever you are ready.
Okay. Yeah, thank you for that introduction, Dee. I'm going to switch over.
Yeah, I think you need to stop sharing for. There we go.
All right. And so you guys can see my screen. All right.
Yeah.
Great. Okay. Let's get started. Thank you, Dee and Dara, for having me on. I really appreciate it. This is I love being a part of LEARN and the meetings that you guys put together. It's nice to have a place where people can come and learn about different aspects of aging and how complicated it is. And that's a really great resource for our community. So thank you guys for putting LEARN together and for keeping it going. It's been great to be a part of it. So today we're going to talk about estate planning made easy. We're just going to go through an overview of what estate planning is, why it should be important to you. And you know, this is something we deal with day in and day out. Our name is obviously Idaho Estate Planning, so it's most of what we do. So we'd love to give you kind of a basic understanding of what estate planning is and, you know, how it fits into your life and your life as you age. So let's start off with what is an estate? So the most common thing that we hear when we used to go out in the community and do presentations and go to conferences and talk to people was that they don't have an estate. And that's not true. An estate doesn't have to be a big manor like this, so like a Downton Abbey or a Tara, and have like this large manor with a long driveway and a butler. It's not about how big your house is or how much property you own. In reality, it's everything you own. So it is everything from your online bank accounts, your cryptocurrency, your investment accounts, all the way down to like the lint that is in your pocket. That's your estate. And so we try to take care of the stuff in your life, but we also want to take care of you and the people in your life as well with regards to this stuff, because it's how we pass down generational wealth. It's how we afford to grow old and live the life that we want to live as we grow old. So it's really important to kind of take into account all of this. So our goals of estate planning, Mark here in our office is our founder and lead attorney. He likes to call estate planning people stuff planning, because we want to plan for people and then for stuff. So we want to plan to control your property while you're alive and well. We want to plan for you and your loved ones if you become disabled. More and more as medicine progresses and stuff like that, fewer and fewer people go from alive to dead in a blink of an eye. There's usually a period of time where they are either mentally or physically disabled or incapacitated. So we want to make sure that everyone is taken care of in those moments as well. And next, we want to give what we have to who you want, when you want it, and in the manner that you want to do it. We want to have control over all of that. And we want to do this at the lowest possible cost to you and the ones you love. And we'll talk about some of those cost problems a little bit later. So like I said earlier, we want to make sure that your estate plan covers you while you're alive. If and when you are disabled or incapacitated, and then after you are deceased. We want to make sure that we take care of everything along that line. So the most common estate plans, these are the 4 most common estate plans that we run across, and that's what we're going to cover today. So the first one, doing nothing. Doing nothing is the default. So everybody has this plan. And it's governed by the rules that happen when you die without a will. That's what intestate means. It means you died without a will. And the state legislature has determined a distribution plan for everybody based on that. If you don't do anything, the state legislature has a default plan for you. And let me tell you, it's not great. It's made for a certain type of nuclear family that wants a certain thing to happen. It's very leave it to beaver and doesn't take into account any sort of complexities when it comes to family relations. It doesn't take into account second marriages. It doesn't take into account children that either don't need money or children that maybe you don't want to have get your money. So it doesn't take into account any of those things. And so if you don't fit that particular leave it to beaver mold, it can create some problems like unintended heirs. The number one unintended heir that most people don't want to have get their money is Uncle Sam. There are the number one goal we see in our office when we talk to people about what their goals are and what they want their estate plan to do is top 5 reasons is I want to avoid taxes, which is great and understandable. This is your money, you've worked hard for it. Let's pass it along to who you want to have it. So there are some avoidable taxes that you will incur upon your death, and they're avoidable if you do some planning. They're not always avoidable if you just kind of go with the default. So that's the number one unintended heir, but there's some other ones like maybe your spouse outlives you, gets remarried, their new spouse could inherit all of your money. It could go to a long lost relative, a cousin's kid, that just happens to be the next person in line. So we can avoid having money go to those places with a little bit of planning. The last one is a really fancy name: unintended pretermitted family members. It's another way of saying you might actually accidentally disinherit your kids in favor for Cinderella's stepsisters. So what happens in this situation is, let's say mom passes away, and they have a kid, Cinderella, and dad gets remarried. Dad then passes away. All of mom and dad's money that dad had now goes to the evil stepmother. And then when evil stepmother dies, it goes to the two stepsisters. Cinderella doesn't get anything when we go with the default plan. So if you want to make sure that your children get money, even if your spouse remarries, you've got to make a plan. And you have to provide for Cinderella, because in the default plan, you unintentionally disinherit Cinderella for kids that aren't even yours. So easily preventable situations that cause a lot of heartache. So, all right. So next, how do we go through the process after somebody passes away? What does that process look like? It's a process called probate, and it is a legal proceeding. There's a judge involved. We are going to court, unless we do kind of an informal situation. The judge is still involved. You just don't necessarily have to show up in the courtroom. So what's going to happen is the judge is going to appoint a personal representative, and it's usually someone who comes to the judge and says, hey, look, mom passed away, dad passed away, my siblings and I talked, and they're okay with me being the personal representative, or can you appoint me as personal representative? Or everybody and their dog in the family comes to the judge and says, no, I should do it better. And then we have a big, long court battle. So, but this personal representative they are given permission to act on the behalf of somebody who has passed away. So the most common thing that we need a personal representative for is selling the house. That is the biggest one. If you are selling property, right, we have to have someone sign their name to sell that property. But if you've passed away, obviously we can't get that signature. So the personal representative is appointed on behalf of that person to take care of those things. We will also go through probate if there is a will. So the judge will enforce any instructions in a will as far as distribution. I don't want to give anything to this kid. I want the classic car to go to this one. Things like that. The judge will make sure that that all happens. The personal representative also gets the ability to transfer property after death, whether that is a bank account or a car or a house, a cabin, etc. They get the authority to do that. So probate also provides a forum for a will contest to say, hey, mom didn't have the mental capacity to make this will. It should be invalid. Or, Steve, the brother, was chirping in mom's ear the whole time, and mom didn't really have any say in whether or not she made this will. So we think it should be invalid. those kind of situations, probate provides a way for those to be litigated and gone through. The downside is probate's time consuming and expensive. On the low end, it's going to be about $3,000, just the very low end. It's time consuming. Probate has to take at least 6 months. So statutorily, like it's written in Idaho code that it has to take at least 6 months. Give time for creditors to come forward and stuff like that. So on the low end, you're looking at $3,000 and 6 months. So if we can avoid that, that would be great, right? That's a lot of time. Most of the probates that we're dealing with right now we're approaching the 10-month mark on the easy ones that are wrapping up soon. So even the easy ones can take longer than 6 months. The ones that are pretty, when I say easy, I mean, they're pretty straightforward. Everybody is getting along. There's a lot of paperwork involved. You have to go to every bank and every account, and it's a lot of work. So if you don't want to burden a child or a loved one with that process, we can avoid that as well. So the big thing, so that takes care of if you've passed away. So working backwards, what happens if you're incapacitated? There is a process called guardianship and conservatorship. It's been in the news a lot lately. So Nichelle Nichols, she played Uhura in Star Trek. She's going through a guardianship conservatorship battle at the moment. Britney Spears. There's a couple others that are pretty high profile conservatorship cases that are happening right now. And these are, Idaho separates it out to a guardianship and a conservatorship. A lot of other places just call it a conservatorship. So a guardianship is where we appoint someone else to be your physical guardian, much like a parent. They will help take care of everything but the finances. They will help you make healthcare decisions, where you're living, things like that. Conservatorship takes care of the money. They're appointing someone to take over your finances because you are no longer capable of making good decisions that way. So we're losing control of either our ability to make choices or our ability to control our finances. And we're losing that control to a judge. We're also losing control of how we determine if someone is incapacitated. So we have to go to court and the court says, yes, you're incapacitated, or no, you're not incapacitated. But maybe we would like to have a family member or a trusted doctor or a combination of those decide, yes, we're not doing well. We can tell mom's not making good choices. Let's maybe we take over for mom, or mom could voluntarily give up that ability. But in a guardianship conservatorship, it's more of a drawn out battle. We're going to have 3 lawyers. We're going to have to go through a big long process, figure out who's going to be the guardian. Do they qualify? Background checks. There's a yearly accounting. It's a very long, complicated process. You can just go read all of the news on Britney Spears right now and get kind of an idea of what this entails. So this is what happens when we start to deteriorate mentally or physically. We have a good family friend right now that has ALS. So mentally, he is still there. He is 100% sharp as a tack. But physically, he is trapped inside of his body. He can't communicate. He can't do anything on his own. So those are like those are the situations where physical incapacity is starting to be a problem. He can't communicate or express his wishes to a doctor, or whether or not what show he wants to watch. So there's a lot of legal issues that can pop up there. Okay, so downsides to guardianship, conservatorship, it's expensive. There are 3 attorneys. So there's one for the guardian and the conservator. Usually a second one for the person who would become the person who needs a conservatorship, and then a third party, a third attorney. There's accounting fees. You have to report to the court every year what happened, what's going on. Here's the money we spent. It's time consuming, and it's all very public. So every time you go to court, that probate or that guardianship or parking ticket or whatever becomes public record. So I can go and search and find out everything about what's going on. We can find out if there's a person who is vulnerable. We can find out if they are vulnerable by just going and searching, what's on the calendar for guardianships and conservatorships. And so it opens you up to some creditors and some predators, a lot of predators, but also it kind of airs all of your family business in a public forum. And for some people, that's not the most ideal situation. All right, so the second estate plan is giving away assets. There are a lot of problems with this. We see this a lot with people who are either trying to qualify for Medicaid or just want to live, they want to give all of their money away to their children with the understanding that the children are going to take care of them. And they're just going to give them that money now. And then either move in with them or expect their children to pay for care. There are a lot of tax issues that come up with this, not only for the person giving the money, but for the person receiving the money. And that can actually be a lot more of a burden than the gift itself is worth. So there are Medicaid planning issues. It can temporarily disqualify you for Medicaid. If you do it during the penalty period, you could incur a penalty where you have to pay private pay for a period of time because you gave that money away. The state essentially goes, hey, you had enough money to pay for this. You could have paid for it. Either get it back or find some other way to pay for this for a couple of months because you could have done it. So that's kind of a tough situation to put people in. You lose control. Once you give money to a child or an institution, you can't dictate what happens to it, right? You gave up control of the money when you gave it up. So that can be problematic. And you can't count on help from family. You don't know. I mean, hopefully you do know what's going on in your children's lives, but there may be some financial issues that they haven't talked to you about that may eat up that money. So it's really, really hard to just assume and count on family to help. There may be an emergency that pops up that they need that money for, that you intended to age with and you gave them in order to help pay for your care. So it's really, as much as we would love to count on our family and depend on them, life happens and it makes it really hard. The last issue is another tax issue, capital gains tax. So if you go and sell your house and then give all that money to your kids, you are going to pay taxes on the profit that you earned from selling that house. So it's really, there's a lot of tax consequences that are easily avoidable with some more planning. Option number 3 is a will. Wills are something. They are a plan. They're better than the state plan for most people. So that's great. For most people, they're better than nothing. There are some circumstances where a will has not been better than nothing, but those are very rare. So a will is essentially instructions for the probate court, for the judge, on how you want your assets distributed and who you want to be your personal representative. A will only is effective after you pass away. So your personal representative doesn't have any power until after you've passed away and the judge has given his stamp of approval. A will can't take care of you if you become incapacitated because you are still alive. And the will is just going to tell your personal representative how to get rid of your property, how to pay your bills, and how you want your assets distributed. It's pretty basic, and it doesn't avoid probate court. You're still going to have to go to court. So in Idaho, we have some pretty lax laws on what constitutes a will. So, which is nice for some people. It does make kind of last minute deathbed wishes a lot easier to express, but they still have to go through probate court, which again is public and expensive and is going to run into some tax issues. So number 4 is a trust. So we like to talk about trust as a bucket, and sometimes as sort of a quasi business for your personal affairs. These trusts are private. They do not have to be known publicly. You don't have to disclose your trust publicly. There's no database where your trust is located if you don't want it to be located. And if no one has, if there's no problem with it, it's great. No one has to know the contents of your trust, which is great. A lot of wealthy people who have trusts or are trust fund babies, but that's all you know. So that's nice. Affords a little bit of privacy. They're immediately effective, which is great. They give instructions for lots and lots of situations. You get to choose who's next in line and next in line after that. And you get to choose who takes over if you're incapacitated or disabled. You get to choose who takes over if you pass away. You get to tell them how you want your property managed, both while you're alive and after you've passed away, how to pay your bills, how to distribute your property. So there's a lot of flexibility with the trust, which is really nice for some people. The really beneficial, there's 2 really beneficial parts to a trust that I really like for people. Number 1 is it's private, right? You don't have to tell anybody about it. You avoid probate court. That's great. The second, and you get to keep it all in the family. We don't have to involve anyone else. We don't have to involve a judge. So it's private, avoids probate. Number 2 is it takes care of you while you're incapacitated or disabled. And it provides a little bit more freedom with determining incapacity and disability. So The trust tells the trustee what to do when you're disabled, but you can also give instructions on how to determine if you're disabled. You can say, hey, if I go to a doctor and my 3 kids and the doctor think that I'm not doing well, they can remove me as trustee, and so I don't have any control anymore. You don't have to give up rights and go to a court and whatever. You can deal with that in the family. And they just take over the finances and the decisions. And it doesn't have to be a big, long, drawn out battle, and you get to pick who it is. There's a really interesting example of this, really weird sports reference. But is anyone familiar with the LA Clippers? One of their owners in the 90s, his name was David Sterling. He owned the Clippers in a trust. So the trust owned the Clippers, and he and his wife were trustees. And there was a lot of stuff that went down. He was not a good dude. But his wife, and he was doing crazy things with the team. And he kind of was mentally starting to slip. So his wife went and got him declared incapacitated and removed as a trustee of the trust that owned his team. So she got him removed because he wasn't capable of making good decisions anymore. So she got him removed and then ended up selling the LA Clippers away because it was too much drama. There's like an 8-part ESPN 30 for 30 series on it that is really great. So there are ways to go about that. And she was able to do that in like a week or something. Like it was pretty immediate. She was able to act and get him removed so that he couldn't do any more damage than he'd already done. So it was really great. That's a really great way to kind of see how that functions in real life. So yes, we're going to get instructions what to do on disability, what to do on death. So a properly funded trust avoids probate, expense, the 6 months, publicity, etc. And we're going to talk about funding a trust here really quickly. This is just the quick rundown. So we like to refer to a trust as a bucket, and the bucket is going to hold all of your assets. And you get to hold the bucket, and you are in control of the bucket until you either give the bucket to somebody else to take care of, or somebody says, hey, you're not doing great, let me take the bucket. So this bucket is going to have all of your assets in it. So it's going to have your house and your accounts and stuff like that are all going to be in this bucket. So most of the time we retitle them. Instead of saying Mary Smith is the owner of this house, it's going to show that the trust owns the house by way of the trustee. So it'll say Mary Smith, trustee of Blackacre Trust, and her successor trustees as the owner. And this allows us to take everything out of your name so that when you pass away, we don't have to go to probate, because you don't technically own anything. Your trust owns all of your house and accounts and everything. You just have control of the trust. So it's kind of a clever, I think it's a clever way to avoid probate, in addition to doing some other great things. So this is a question that I got about 25 minutes before I got on this call. Can I just do everything with a power of attorney? I literally just got this call. And no, you can't do everything with a power of attorney. There's no there's no method for accounting for what you do as a power of attorney on behalf of somebody else. So there's no oversight. There's no one to come in and say, hey, I think you're spending too much of mom's money, or I think you don't have her best interest in mind. So there's no method for that to happen. And that can lead to some abuse issues. And we want to avoid those and put as many kind of safety nets in place as possible. There are some financial institutions, banks, that struggle with accepting powers of attorney that are over 6 months old, or 3 years old, or 10 years old, or they want you to fill out your own their form, which is terribly problematic, because usually if you're coming into a bank with a power of attorney, somebody has already either given up their ability to act, or they're unable to sign on their behalf. So it's hard to sign a power of attorney for a bank if you're coming in with a power of attorney in order to get stuff done. So it causes so many issues. Powers of attorney are only valid while you are alive. So the second you pass away, whoever was acting on your behalf as a power of attorney no longer has that authority. So that is can be troubling to get your affairs taken care of and put in order after you pass away. So it takes care of you while you're alive, but not necessarily after you pass away. And there's some legal formalities that a power of attorney has to observe that they might not have to observe if they are a trustee for your trust. So yeah, there's some complications. Another thing we like to make sure that people have in their estate plan is a living will. Most states call this the advanced healthcare directives. Idaho just hasn't gotten it together, and we still call it a living will, which is a really unfortunate name for this document. It's often confused with a DNR or a post. It is not one of those. You do need a post, so go talk to your doctor if that's something that is relevant in your life. Go talk to them and get that taken care of and get that on record, because those are very important. A living will takes care of a particular situation. I always refer to the Terry Schiavo case just because it was very public and very publicized, and everybody got to hear about it for years. But it is for that type of situation. It's for an event where you're unable to communicate your wishes, and death is likely or brain activity is unlikely to return. These are persistent vegetative state situations. And so the living will kind of gives you 3 options. Plug me in, hook me up, do everything you can to keep me alive as long as possible. Spare no expense. Let's do this. There's a chance I might come out of it. Number 2 is keep me comfortable, but disconnect me from all the machines. I don't want a ventilator. I don't want any other machine artificially extending my life. Just, give me an IV to keep me hydrated, and give me a feeding tube to give me food. And then option number 3 is, it's honestly the one we see the most people choose, is keep me comfortable, give me morphine, but disconnect me. I'm in a persistent vegetative state. Let's just let life play out as it will, but keep me comfortable. So those are the main things we look for in an estate plan. There's a couple other documents that we like to have. In addition, there's a healthcare power of attorney that allows someone to make healthcare decisions on your behalf if you're not able to communicate those decisions. If you're in surgery and the doctor has a question or needs an answer or permission to maybe do an additional procedure while you're under, something like that, that healthcare power of attorney can act on your behalf and say, yes, go ahead, take out our appendix while you're in there. The other one that we like to include in our plans is a HIPAA directive. This HIPAA authorization when you go into the doctor, you sign a HIPAA form that says, please don't talk to anybody about my healthcare and the decisions that I've made. So that prevents the doctor and the medical staff from releasing your healthcare information. We like to have a form that says, please give my healthcare information to these people, my kids, so that if I'm in the hospital, they can ask the doctor questions and the doctor can give them answers. They can't necessarily boss the doctor around unless they're the healthcare power of attorney, but they can at least ask questions and get answers, and that helps prevent a lot of anguish. It also helps with people who end up having chronic hereditary issues, to kind of ask questions and find out if they need to take some actions a little earlier. So I think that's really important. So where do we start? Step one, get real. This is the kind of just suck it up kind of a moment, that this is really going to happen at some point in the future. Yes, we're going to have to deal with, what if I'm incapacitated, or what if I die? Those are questions that are going to be answered. I mean, we are going to die eventually, and that's kind of the get real moment, is like just accepting that fact. Number two, just get motivated. Something needs to get done. Number three is kind of getting it together, kind of assembling your thoughts and your wishes and kind of figuring out what you want. Step four is get help. Give us a call. And step five is just to get it done, to just do it, do the thing. Yeah, so those are the five steps that we recommend. And yeah, that's really all I have. Do you guys have any questions? I've got a couple more slides. But does anyone have any questions while we're...
You can come off mute to ask a question or put it in chat, and we can answer that way if you prefer. Carol?
So what would one expect to pay for a living trust, or a trust of some sort?
It really depends on how much the trust needs to do, whether it's pretty standard or whether it needs to be all the way up to, it needs to take care of our Medicaid planning, or really complicated estates where we're doing some estate tax. We're trying to avoid some estate taxes. Right now it's like at 11.25 million or 11.5 million per person. So if your estate's worth more than that, you will have to pay estate tax, but not a lot of people are at that point. So we don't have to deal a ton with those. And it just depends on when it happens. So when that estate tax thing changes, so it can be anywhere from $3,000 to 10, 12 grand, depending on how complex it needs to be and how much heavy lifting it needs to do. So
Okay, and then if you go along and need to make changes and things, you just kind of pay based on the work that's needed?
It really depends on the firm. Some of them will do those changes hourly. They'll pay an hourly fee and you just kind of pay as you go along. We have a great program here. We call it our Legal Life Plan Protector Program. And it is a subscription program. So you pay every year. And that provides you with phone calls to the office and changes to your plan. And you get to come in every year. And we're going to sit down, we're going to talk about your plan and talk about what's going on in your life and see if there needs to be any changes. If we need to add people, take people away. If there are new situations in your life that we need to account for. And then kind of keep in touch with and get into our office every year. And so that's how we do things. But I know other firms will do kind of like an hourly fee for any changes that you need.
And that subscription is a set amount every year?
Yes, it is.
What would that be?
I believe it is $6.95. So
Okay.
yeah, so it's a great value just in getting to come in to the office and sit down with Mark or I and Patty and kind of go through your whole plan. It's worth it just for that.
So Carly, what are some of the kinds of things that people could be doing now to kind of protect some of their assets without an estate plan?
Without an estate plan, a great one is to call your financial advisor if you have one and take a look at your pay on death beneficiaries, because there are certain accounts that don't have to go through probate that can go directly to your descendants after you pass away. But you have to make sure that the names are correct on those pay on death beneficiaries. So that's something that like everyone can do on their accounts.
Excellent.
And we like to harp on that a lot because it gets overlooked, and we've seen some really interesting situations that happen with those, particularly when it comes to divorce. Husband and wife married, they get a 401k or a different account. He puts her as the pay on death beneficiary. They get divorced, he gets remarried, never changed that pay on death beneficiary. And so ex-wife of 25 years is now getting this giant chunk of change from this account because nobody bothered to change the pay on death beneficiary. So that's a really easy way to avoid a lot of problems.
Just make sure those
require a lawyer.
Make sure those stay current. Don't just set them up, but make sure they stay current. There is an
Yeah.
option. Is there also an option, Carly, to you can, instead of a pay on death beneficiary, you could put those accounts in a trust if you create the trust, so you don't have to worry about maintaining that current
Yeah. I
information.
mean, the trust is obviously the best way to go, but it's not always ideal for everyone.
Yep.
But those pay on death beneficiaries, everyone needs to do those.
Does that apply to banking accounts as well, or just investment type accounts?
It depends on the type of account. Yeah. So
Sharon, did you have a question?
I did. So when you showed your screen, the one screen said a revocable trust. There's a difference between a revocable trust and an irrevocable trust. Is that correct?
yes,
One
there
is that you can access any amounts in it at any time, the trust holder, on a revocable. But an irrevocable, you can't access it. Is that correct?
It's about the ability to change and dissolve the trust. So a revocable living trust is you're able to revoke it or change it or make any modifications to it. An irrevocable living trust, you aren't able to make any changes to it. And we see these a lot in Medicaid planning, where we want to make sure that the trust maker or the person we're trying to get qualified for Medicaid doesn't have the ability to access those funds willy-nilly. They have to go through a third party, another trustee, to do that on their behalf.
Okay.
And Carly, one of the other things you were talking about guardianship and conservatorship, and I think that part of that is if you should need to have that put in place for you, none of us want to think about that. That you have an option to spell out who you would like it to be, assuming
Yeah.
the court approves it. Where does that fit into the estate plan?
So yeah, we try to avoid guardianships and conservatorships with at least the money part of it with a trust, right? So we are giving we're transferring all of our belongings from our own name to the trust name. We're putting them in the bucket. So when I am removed as trustee because I can't make good decisions anymore, all of that money is still for me and is still for my benefit because that's what we've written in the trust. But someone else is the trustee and gets to control the flow of that money and where it goes. So we get to give up that financial part of it through the trust. And we can also do some of that with the powers of attorney, the healthcare, the financial power of attorney. But for the hardest one is the money part. So it's really, trust is a great tool to avoid that.
Hi, this is Teresa. I have kind of a silly question, but is it possible to set up a trust and have nothing in it?
It is, it just doesn't do anything. The trust can only govern what is in the trust. So
no, I understand that. But as far as if someone does have a trust, then you can assume that there is something being covered in the trust. Does that go hand in hand, or is it possible that someone would set up a trust and the attorney might say, "Oh, we'll get to putting stuff in it later," and then them never do that?
Yes. Oh man, that is the bane of our existence here in the office. Yeah, so it's very common to see trusts that don't have anything in them, or they may a lot of trusts have like, there's $10 in this trust, and just by way of how the paperwork is set up. Unless you take the time to retitle those assets into the trust, that trust remains empty. So everything that stays outside of that bucket, that doesn't get retitled or anything like that, has to go through probate, which defeats the purpose of a trust, one of the purposes of a trust. But the problem is that funding, man, we see a lot of people that just are like, yeah, okay, so I put together this bucket. I'm good. I'm done. I'm not going to worry about finishing the journey and putting all those assets in, just because it's time and effort and sitting on hold with your bank. So it does get forgotten. We try to put in a backup that says, we call it a pour over will. Mark calls it the pooper scooper will, because it essentially acts as a pooper scooper. We're going to scoop up everything that didn't get put into the trust, maybe forgot to get put in the trust. And this will goes to probate and says, hey, judge, look, I know I've got this trust. Can we just do everything that we need to do and just do it as I put in the trust over here? So like, these are the guys I meant to have be my personal representatives. This is how I wanted everything distributed, and I messed up. Can we just like scoop it all up and put it in the trust? So yeah, that is available as like a backup plan. Like we never want to use that. But it's there as kind of a safety net.
And it's honored by the judge.
For the most part, I mean, there are some other circumstances, whether or not the judge believes that the will was, you were of sound mind when the will happened, or, you know, if someone wants to doubt that signature or is mad that they got cut out, you know, there's always that contest. But yeah, for the most part, I mean, that provides a lot of instruction for both the judge and the personal representative.
Carly, what kind of resources are available, or are there resources available to help fund the trust? Because I think this really is the challenge, right? That you get that trust bucket and you hope to have the pour over will, but are there resources available to help people manage that process of making sure that the bank accounts and the financial accounts and the insurance accounts and the, you know, does your firm do anything like that, or do you outsource that if somebody just doesn't know how to do that?
So we are more than happy to help you keep track of your assets and what you put into the bucket. And when we meet with you every year, Patty usually sends out a report card, which is super fun. I find it very fun. But we'll send out a report card kind of saying like, okay, well, great, you got these things moved into the trust, but we're still waiting on this timeshare and we're still waiting on this over here, as just kind of a gentle reminder. And we're also available, you know, to help guide people along that path. And there are lots of financial professionals like that we love working with your accountant and your financial advisor and your insurance agent. We, you know, are more than happy to coordinate with them. And if they need help moving those over, like we're more than happy to do it. It's really unfortunate that we can't do it ourselves for you, just because we can't move your money for you. Just because we don't have that authority. We're not you. So yeah, we're happy to like guide you and kind of keep you on track with that, and kind of help you navigate that when it gets a little tricky.
All right, I have one more if nobody's going to jump in. So
Okay.
powers of attorney stop being effective upon death,
Yes.
but the trust lives on.
The trust lives on as long as you want it to live on. There are like there's Rockefeller trusts that are still around that have like cascaded and moved down to younger and younger and younger generations of some of those big like oil barons. Yeah, so that trust can live on and on and on as long as you want it to, and as long as there's something in there.
Other questions? Thank you, Carly. Anybody else have a question? Sharon, you look like you're about.
I think I do.
Okay.
Yeah, I think I do. So I'm gonna go back to the irrevocable trust again. I
Sure.
work for the Office on Aging, and I am the manager of the social services, and we get tons and tons of calls from folks who are wanting to salvage their house from Medicaid. And in all of these estate planning webinars that I've done over the 24 years of my life in this business as of today, I am telling people that that's not going to happen. They're likely not going to be able to give away their house to their kids, avoid the penalty, even in an irrevocable trust, because they would have to sign the house over. And if they're owing money on it still through a bank, The bank's not going to let them do that. Am I right in that?
It's complicated. It is a,
Yeah,
it is, an hour is not enough to go through that. But there is a simple solution, and it is doing that planning before that 5-year look back period starts. Because we can avoid those
right.
things. We can, make sure that the house is safe and you're able to give that to your kids. The big one is the family cabin. That's the one that we see a lot of people come in
Right.
for, is like, I want to give this cabin to my kids and I want them to have this because it's been in our family for generations. I want them to have this, but I don't want Medicaid to come get it. So
Right.
the earlier the better. If you can get in and we can start and we can protect those assets and we can make that, and we can do it before we start the 5 years that they're going to look back, we can
Mhm.
do a lot with that. So yeah, the on the back end, after, when we're already on Medicaid and we're trying to, protect some things, it is hard and difficult, and we're not going to get the outcome that we want. But if we can
Right.
plan early and get through that process early, we can do a lot of good and and avoid those situations.
So even in an irrevocable trust, the look back period, that the trust would have to give the ownership back to that person
So I would give up
that was
ownership.
needing Medicaid.
Yeah. So if I needed Medicaid and I know I'm going to need it,
Mhm.
7 years from now, and I give up my ownership in the cabin to the Carly Ward Irrevocable Trust, and my sister is going to be the trustee. So I don't own it and I don't have control of it. And we can wait out that 5 years. It's not mine when I go to apply for Medicaid. So yeah, we can do a lot of things early.
But if you're in that 5 years, say you plan and something happens and in 5 years hasn't happened yet, then the trust would have to give it back to the person that needed the Medicaid. Is that correct?
It gets complicated then.
Or there's the penalty.
Yeah, really, really
Either way.
complicated. So the earlier the better.
Okay.
Yeah, no, it would take
Thank you.
hours to go through those. Yeah.
But I think Sharon, the right answer is it's not as simple of moving it to an irrevocable trust that won't protect it, right? So I think if that's the message you've been giving, and people think they can create an irrevocable trust to protect it, unless it's 5 years or longer, it's complicated, as Carly said, and it's unlikely to have the outcome they want. I
I
think
could give you the typical lawyer answer and just say it depends.
it depends.
Yeah. So,
And that's not what we've been telling people. We've been telling people that that's not going to be their answer,
yeah,
in most cases.
if you don't plan early, it's not going to turn out the way you want it to. Yeah, it's going to be hard. Yeah. So I just have if there's no more questions, I have a really quick plug. We are hosting our 2nd annual No Place Like Home conference. This is a virtual conference, so it'll be a lot like this, except we're going to have a lot more people on one screen than just me. But we want to talk about what it takes to age in place. We know most people want to stay at home when they age, and we want to talk about what it takes to accomplish that. And if we can't stay at home, how do we make home wherever we're at? So this year we want to take a look at multi-generational living and aging, If you're aging with family close by, or you're moving in with a son or a daughter, and what those situations look like, and how to kind of navigate those family dynamics, how to deal with, more often than not, the reason why an aging parent has to move in with a kid is because of either a fall or a serious medical event. And we want to kind of walk through that whole situation and how, what needs to happen there, and how to kind of navigate that whole situation, and how to deal with kind of the family dynamics of parent and child living together, maybe some role reversal, and things get really complicated. So it's free. It will be virtual. We don't want to have caregivers go find respite care in order to come to this conference. So we've made it virtual. If you want tickets, it is at AgingInPlaceIdaho.com, and it'll be October 13th through the 15th. And Dee here is going to be one of our panelists, and I'm really excited for that. So luckily I will be behind the camera and Mark will be in front of the camera, so you'll get to meet him and you know, experience him as a lecturer and as a host. So that'll be really fun. So yeah, you can go sign up and get tickets there. And if you want a free copy of Mark's book, go check out our website at idahoestateplanning.com. You can get a copy of his book. We'll send it out to you for free. And it goes over those 5 steps that we talked about a little bit more in detail, the get real, the get motivated, get everything together, and to get help and get it done. So this will go through a lot more detail. This is kind of, today was estate planning basics 101. This will be like 102 for you. So it takes it up a notch. So yeah.
This is Shannon Skidmore, and I apologize. I didn't want to interrupt. If I could just add one thing for those that are on this webinar. I have worked with you all for several years. I've been in the senior living industry for 15 plus years. And I've seen this both ways, those that have had it planned and those that have had not gone through the process, and what that does to the family members. So being proactive on this and just at least setting up that initial appointment and going through that process, it makes a world of difference when the inevitable happens. And I just wanted to just throw that out there and just to provide some comfort. I've seen this on both ends of the spectrum. Again, you know, living in a senior living community, and then for those that are at home, and what a world of difference it makes when you take those steps in process. And the financial piece, yes, it can be a little scary on what it may cost, but you don't know, but the relief it provides to the family members and the relief that it provides you, it's well worth the process of it.
Yeah, thank you.
Absolutely.
Thank you, Shannon. And we have the slides for from Carly's presentation out on the Idaho LEARN-USA-AgingAndCaregiving website. Dara had sent out a link to those, and she'll send out a little notice again in just either later today or in the next few days, so you can access not only the slides, but the information about the Aging in Place conference that they're doing. So we have a flyer out there for that as well. So just as a tickler, and you're welcome to share that with anyone that you think it would be relevant for, because I think all are welcome, unless there's a limit that I don't know about, Carly.
No. Yeah, it'll be broadcast virtually, so we don't have a cap.
Excellent. Any other questions or comments? All right. Well, Carly, thank you so very much for your presentation today.
Yeah,
I am going to take back the screen here.
Yes.
And oh, here we go. Give us a call. That was a great piece there. So being the technical wizard that I am, are you seeing all the people, or are you seeing my
I see your PowerPoint.
My PowerPoint over here? Excellent. Well, let's go from the current slide. So again, Carly, thank you very much for your time and energy in putting this presentation together. It is very important that everybody be not only thinking about this, but taking action on this and taking action. If you haven't picked up that message from Carly today, taking action early is definitely in everyone's benefit. And so I thank you very much for the presentation today. I'd like to thank Fairway Independent Mortgage again for sponsoring our presentation today. And if you're interested, we would love to invite you to join our Learn mailing list for future presentations that we'll be doing. So all of you that were on the presentation today will receive an email inviting you to join our mailing list. We don't automatically add you. You must choose to join and confirm your subscription to receive information about future community education opportunities. And coming up next, later this month, we have retirement living options with Catherine Owens, a subject matter expert and a delightful presenter. Guardianship and conservatorship in more detail. So Sean Beck will be presenting that for us. And we're going to have Fairway Mortgage presenting understanding reverse mortgages. And I know this is one that I am very interested about because we've heard so many negative things about it for so long. I think an opportunity to ask questions and hear the real scoop on what that's going to look like for potential options to fund our retirement and the living options moving forward. And then finally, for the this quarter, we will have fall risk prevention with someone who does the training regularly for fall risk prevention and how important that is. I know that as I have gotten older, that I do lose my balance a little more often than I used to. And so we have to be very cognizant of that and how do we strengthen that so that we don't hurt ourselves and end up in a situation that we don't want to be in. So again, I thank you all very much for joining. Feel free to take a look at our handouts and sign up for any of the future webinars. We post them to our website, LearnIdaho.org. And you are welcome to go back and see any of the previous presentations that have been done. They're all recorded, as will this one be, if you'd like to refer it to family members or your spouse, anyone that would take it, find it helpful to understand a little bit more in depth. And again, thank you all for being here today.